Well, good morning, everybody. Welcome to our third day of pre-licensing, last day of this week. Congratulations on all that you've done so far. And we just have 3 more sessions today, and then you'll be done with that piece. And of course, we continue next week. We have the main conference next week, so we'll be joined by many more of your soon-to-be new colleagues in the enrollment assistor world. And yeah, really looking forward to that. So next week, as a reminder, we'll have the same kind of schedule. So it'll be Monday through Wednesday. We'll start again at 8:30 and we'll conclude each day around noon. I think Wednesday we end a little bit earlier, which is nice. And I just want to thank again all of our speakers this week from DHS and OCI, and definitely Elizabeth and Adam from Covering Wisconsin. Elizabeth has done all the coordination this week, so thank you so much for that. And just all the work that these speakers have put into this. It's a big lift, but it's really important because it's important information for you, and we really just want to make sure that you feel prepared. To that end, just a reminder that there will be an evaluation that would be incredibly helpful if you complete it for us. Like I said yesterday, we do look at these. We some as we plan for the next year and just make sure that your feedback is incorporated as much as possible over the years to try to accommodate the things that you all have or those in your position have raised with us that have been really helpful. Trying to think. Oh, and actually, related to the evaluation. So you will both get an email right after the end of today's sessions, around noon or so, from the same email that you've been getting your login link each day. So do take a look for that. If alternatively, maybe a more convenient way for you to access the survey, and again, it's very brief, it's really quick, it shouldn't take you very long to complete. It will be located in the last session on the platform. I believe it's going to be in kind of the upper right-hand corner, so you can fill it out as you complete that session. Just while all the information is fresh, it's just going to ask you about just some of your takeaways and reflections on the sessions and what was helpful and maybe other ideas for improvements for the future. And yeah, I think that's all I wanted to share today. I think it's been great to have you. And like I said, we will reconnect again after today on Monday. So with that, I'm going to hand it over to Elizabeth to start us off.
Good morning again, everyone. As Allison said, it is our last day of pre-licensing. We have 3 presentations today, and then we will resume again on Monday for the main conference. So please join us again on Monday at 8:30. Today we start with the Office of the Commissioner of Insurance, and we will be doing an introduction to insurance with Sharon and Shelley. So I will go ahead and hand it over.
Good morning again, all. This is Shelley. Thank you, and we made it to Friday, so yay. Friday, kind of strange to say, but we made it. So here we go. If you can go to the next slide, please, Elizabeth. The Office of the Commissioner of Insurance, also known as OCI, was created by the legislature in 1870, and it continues to work today to make sure that the insurance industry meets the insurance needs of Wisconsin consumers. Next slide, please. OCI's mission has both a consumer component and a company component. In addition to helping consumers navigate the insurance marketplace, we also ensure companies are healthy from a financial perspective in terms of having reliably compliant business practices. This helps to ensure that Wisconsin consumers continue to have plenty of dependable choices. Next slide, please. We serve as a resource for consumers, insurers, and agents on a practical level. We also monitor marketing activity for misleading or deceptive practices. We help consumers connect with resources for help in making new enrollment choices, and will investigate consumer complaints to ensure that substantiated complaints are referred to our legal unit for possible administrative action. Next slide, please. These are numbers from our insurance report that released for calendar year 2023. Regrettably, we didn't have the most recent report available until after these slides were finalized. But an overview states that in 2022, there were 2,044 insurers authorized to write business in Wisconsin, with 329 of those domiciled in Wisconsin. There are over 214,000 agents licensed to do business in Wisconsin, and over 34,000 of those are Wisconsin residents. In 2022, OCI investigated and resolved 2,678 written consumer complaints and handled over 19,000 general inquiries received via email or telephone. And lastly, OCI assisted complainants in recovering over $9.2 million from insurers. Next slide, please. Some of the duties and powers of the insurance commissioner are to protect and educate the public and to ensure insurance industry meets the needs of its consumers responsibly, adequately, and even-handedly. Next slide, please. The Commissioner shall administer and enforce the insurance chapters and shall have all powers specially granted or reasonably implied to enable the Commissioner to perform the duties to administer and enforce the statutes and regulations. Those considered doing the business of insurance are regulated and required to have a certificate or license. Also, the Commissioner is granted the authority to require responses of licensees. The Commissioner also has the authority to require from any person subject to regulation under Wisconsin insurance law, such as agents, insurers, navigators, and agencies, the following: a statement, a report, or answers to questionnaires, and whatever information is reasonable from the Commissioner to designate at such reasonable intervals as the Commissioner may choose, and a full explanation of the programming of data processing systems, computer systems, or any other information storage system or any communication system in use. The Commissioner may recommend forms for these reports and specify who must execute or certify them. The Commissioner may require verification of any report. And lastly, the Insurance Security Fund was established to provide certain protections to insureds in the event of an insurer's liquidation. Money in the fund comes from assessments against all insurers, with some limited exceptions licensed to transact business in this state. This fund is administered by a board of directors that include the Attorney General, the State Treasurer, and the Commissioner of Insurance. Excuse me, next slide, please. The Commissioner is granted broad authority to regulate the insurance industry by balancing consumers, insurers, and legislative requirements. The legislative note to the introductory section of the insurance statutes state, insurance is an area of free contractual activity except as restricted by the insurance code. This freedom to contract allows a free marketplace and the responsibility of OCI to monitor the marketplace to maintain a level playing field. Next slide, please. There are three key pieces of this specific statute: the balance solvency of insurers, fair and equitable treatment of insureds, and legislative direction and oversight. The ability to have freedom of contract and freedom of enterprise requires a level playing field and accessible and understandable contract terms. The purpose of this is to provide for an office that is an expert in the field of insurance and has the authority to enforce Chapter 600 to 655 of the Wisconsin statutes, encourage full cooperation of the office with other regulatory bodies, both of this state and other states, and of the federal government, improve and thereby preserve state regulation of insurance, encourage self-regulation of the insurance enterprise, and encourage loss prevention as an aspect of the operation of the insurance enterprise. Next slide, please. Enforcement by state agencies is conducted through administrative proceedings. A neutral judge hears the facts and evidence and renders a preliminary decision with the final decision issued by the commissioner. Because the commissioner is the final adjudicator, they are walled off from matters that may be contested, but they are fully engaged. Whenever a person fails to comply with an insurance law, regulation, or order, the commissioner may start a legal action, directing the person to comply with the commissioner's order and restraining that person from further noncompliance. In addition, forfeitures, license revocations, suspensions, civil penalties, and criminal sanctions may be leveled by the commissioner. The commissioner must hold a hearing before issuing an order or rule whenever the insurance laws or the administrative procedure requirements expressly provide for a hearing. Unless the insurance laws prescribe special procedures, all hearings must comply with the procedures set out in Chapter 227 of the Wisconsin statute and Chapter 5 of the Wisconsin Administrative Code. The statutes do provide for the summary suspension of an intermediary's or navigator's license if the commissioner finds that public health, safety, and welfare require such emergency action. If the intermediary or navigator fails to pay a fee when due or fails to comply with continuing education requirements, the commissioner may revoke the license without a hearing. Also, a license must be revoked if the intermediary or navigator is liable for delinquent taxes or unemployment insurance contributions as certified to the commissioner by the Wisconsin Department of Revenue or the Wisconsin Department of Workforce Development. Next slide, please. One section within Division of Market Regulation at OCI is called Agent Licensing. The Agent Licensing Division has four main parts: the licensing of insurance intermediaries, regulation of insurance marketing practices, compensation of insurance intermediaries, and the licensing and regulation of navigators and non-navigator assisters. The licensing of intermediaries and navigators is concerned solely with the qualifications of the person applying for that insurance license. The essential requirement in this is that they be trustworthy and competent. Competence includes a basic understanding of fundamental insurance law as well as knowledge concerning specific statutes and rules. Wisconsin insurance statutes outline and define the general requirements which the insurance intermediary must follow. In addition, the insurance intermediary must understand and follow the administrative code which has been adopted by the commissioner. General statutory language is expanded and clarified for agents and companies that practices for being allowed and or prohibited. These rules are strictly enforced by the commissioner. Next slide, please. So you may ask, when is an insurance license required? Simply put, in most instances, a license is required when a person is doing the business of insurance. Persons may be exempt if the functions they perform do not require special competence or trustworthiness, or to achieve other purposes that are stated in Chapters 600 to 655 of the Wisconsin statutes. Regulatory surveillance is made possible by the licensing. Next slide, please. So here are some scenarios in which a license may or may not be required. Scenario number 1, a person who incidentally advises other persons about insurance needs and coverages during the normal course of his or her non-insurance related business and who receives no direct or indirect compensation on account of any transaction which results from the advice. So the answer in that scenario is no. This person comes under the exceptions listed in Wisconsin Statute 628.02 and is not considered an intermediary. Scenario number 2, a person who places insurance for an insurance company on a door-to-door basis. The answer there is yes. Under again Statute 628.02, this person is an insurance marketing intermediary and is required to obtain a license. And lastly, a person who advises another person about insurance needs and coverages and is directly compensated by an insurance company or the insured. And again, yes, that answer is under statute 628.02. This person is also considered an insurance marketing intermediary and is required to obtain a license. Next slide, please. The definition of risk relating to insurance is the uncertainty of a financial loss. The risk tolerance is the amount of risk one is willing or wanting to take on by themselves or can afford to take on for themselves. Insurance is defined as a transference of risk. One pays the insurance company to take the financial risk from you to them for a fee called a premium. Typically, the more risk you transfer to an insurer, the higher the premium is for the product as the potential for loss is greater. Often, you will see lower premiums with group products. The reason for this is the law of large numbers or pooling of risks. The insurance agreement is a contract and governed by contract law. The basic elements of a contract are an offer of coverage, acceptance of the coverage, consideration, also known as the money, and an intention to create a legal relationship. Once entered, a contract is enforceable. For example, you identified an insurer offering health insurance and you have selected from the available options to purchase. You reviewed the policy, also known as the contract, to ensure that after you pay any member cost sharing, the insurer will pay the remainder as defined under that contract. During the period, which is typically 1 year, you will look to the insurer to fulfill its obligations. Next slide, please. So in regards to insurance contracts, number 1, the laws and regulations in our chapter apply to all insurance policies delivered or issued for delivery in the state for the following: persons residing in Wisconsin when the policy or group contract is issued, property ordinarily located in Wisconsin, or business operations in Wisconsin. With regards to readability of policies, INS 6.07 establishes the minimum standards for legibility, coherence, and understandability in consumer insurance policies on a scale of 0 to 100. If it scores 100, it is easily understood by the average 11-year-old. But if it scores a 10, it is very difficult to read and best understood by university graduates, as there are many levels of understanding in between. When is a notice to an is notice to an agent notice to the insurance company? The answer to that is yes. The insurance company has been notified if the company's authorized agent has been notified by or on behalf of the policyholder or an insured and provided with sufficient information to identify the policy in question. Every insurer is bound by the acts of its agents performed in Wisconsin that is within the scope of the agent's authority. The insurance company remains bound while the agency contract is in force or until the insurance company has made a reasonable effort to recover from the agent its policy forms and other documents from the agency. An insurance company is deemed to know any fact material to the risk or that violates a condition of the policy. If the insurance company's agent, who's transmitted the application to the insurer, knew the fact at the time he or she acted, or if afterwards any of the company's agents learned the fact during the course of dealing with the policyholder as an agent and knew that the fact pertained to the eligibility of the policy. Misrepresentation by is the written oral use statements which incorrectly describe the terms or benefits of the policy. Representations are oral or written statements made by the applicant. Insurance coverage is issued on the basis of the applicant's representations. A material misrepresentation is an untrue statement made by an applicant that would influence a prudent insurer in determining whether to accept the risk or in fixing the amount of premium in the event of such acceptance. And lastly, Wisconsin consumers are provided with protections and privacy protections and medical and financial information. These laws correspond with the requirements under the HIPAA and the Graham-Leach-Bliley Act enacted in 1999. Chapter INS 25 of the Wisconsin Administrative Code addresses insurance agents' responsibilities when sharing consumer and customer private, personal, financial, and health information with third parties. Insurance agents may, for the most part, rely on the insurance companies for which they are listed to provide those requirement notices and disclosures. Wisconsin also enacted a statute that regulates the disclosure of medical information. It places restrictions on both insurers and the persons that regularly assemble or collect medical information for the primary purpose of providing the personal medical information to insurers for the determination of an insured's eligibility, benefit or payment, or the servicing of an application, policy, or certificate. The rule also establishes restrictions on the sharing of health information. In addition to health information, Wisconsin has also enacted rules that require insurance companies and agents to provide written notice of its privacy policies and practices. The rule describes the condition under which insurance companies and their agents may disclose non-public personal financial information. The rule also establishes requirements for privacy notices. And as far as the right to file a complaint, yes, insurers are required to notify their insureds of their right to file a complaint with the Office of the Commissioner of Insurance regarding any problems they may have with their insurance. The notice is required once for each policy or certificate issued by an insurer. Next slide, please. So we've come to our first polling question. And the question is, an insurance company is bound by the acts of its appointed agent when the agent acts within the scope of their apparent authority, even if they do not have an actual authority from the insurance company. True or false? Give you just a couple more seconds here. All right. So again, the answer to this would be true. Yes, they are bound by the acts of their agent, as we just talked about in the previous slide. Next slide, please. So in regards to the notice of claim, proof of loss is to be furnished to the insurer as soon as reasonably possible and within 1 year after the time it is required by the policy. An example of this would be submitting a prescription cost receipt in a timely manner for something you had to pick up while you were on vacation once you returned home. For prompt settlement of claims, unless otherwise provided by Wisconsin law, subject to an interest payment, an insurer must promptly pay most insurance claims within 30 days after receipt. The effect of a mistake in an insurance contract. So, what is the illegal effect of a mistake in an insurance contract? It says, unless otherwise provided, general contract law applies to mistakes in insurance contracts. For example, in property insurance, a mistake is designated to a mistake is designating the person to whom an insurance is payable does not void the policy. Such a mistake does not constitute a defense for the insurance company unless the mistake was due to misrepresentation or concealment by the owner of the property. Next slide, please. What are some examples of unfair claim settlement methods and practices? One example is the failure to promptly acknowledge pertinent communications with respect to claims arising under insurance policies. Another, the failure to promptly provide the necessary claims forms, instructions, and reasonable assistance to insureds and claimants. The failure to attempt in good faith to effectuate fair and equitable settlements of claims in which liability has become reasonably clear, and knowingly misrepresenting to claimants pertinent facts or policy provisions. Regarding the right to return a policy, each line of insurance has a period the consumer can return the policy without penalty. Life insurance, for example, is a 30-day after delivery for a full refund when the new policy sold as a existing one. For health insurance, a policyholder may return an individual health policy within 10 days after the returns the policy within that 10-day period. The insurance contract is invalid and all payments made under that contract must be refunded. The right to return must be printed on or attached to the first page of each individual policy. Regarding grace periods, although an insurer may cancel a policy for non-payment of premiums, a consumer is entitled to a grace period for the payment of any premium due. During this grace period, coverage does continue. Per state law, for health insurance policies, it is not less than 7 days for weekly premium policies, not less than 10 days for monthly premium policies, and not less than 31 days for all other policies. A consumer should always check their policy to see if their insurers include a grace period provision. ACA plans will have a different grace period depending on whether or not they are receiving the advanced premium tax credit or not. Next slide, please. Here are some examples of plans that in general do not fall under the jurisdiction of our office. Self-funded ERISA plans are typically large employers that are governed primarily by the U.S. Department of Labor. But when a state's law or regulation is related to the business of insurance, the state may retain jurisdiction over that piece of the plan. There are a few self-insured employer plans that fall outside even the federal jurisdiction, such as self-insured non-federal plans, governmental plans, and church plans. Labor union and employee welfare plans are also governed by the U.S. Department of Labor. Discount plans provide discounts on medical procedures with certain doctors or medical related costs, such as prescriptions, just like using a coupon at a store. These plans are not health insurance plans in the traditional sense. Medicare Advantage plans are the federal government's version of a Medicare HMO. The Centers for Medicare and Medicaid Services, also known as CMS, directly contract with insurers to provide the Medicare benefits. States have negotiated and retained jurisdiction over the agents as they are their licensees. Medicare Part D is the prescription drug plan that is sold separately from Medicare supplemental insurance and is provided coverage by the federal government. Healthcare sharing ministries were the original form of the GoFundMe accounts. In Wisconsin, there is an exception for members of a denomination or organization that agree to help financially support fellow members. The member is required to pay any medical bill first and then post their needs in a newsletter for other members to be able to donate funds to help offset that individual's expenses. And lastly, direct primary care is reemerging from the past. Typically, primary care internists or family practitioners negotiate directly with the consumers. OCI does monitor these offerings as frequently there is a component of risk transfer. Next slide, please. So some of the supplemental policies that are defined as not ACA compliant are limited benefit plans and other products that may be marketed in a way that looks like an alternative Affordable Care Act or ACA product. Fixed indemnity health insurance is a type of medical insurance that pays a predetermined amount or on a per period or per incident basis, regardless of the total charges incurred. These do not provide coverage for the essential health benefits. They can exclude pre-existing conditions and also have annual or lifetime benefit limits, as well as defined benefit limits for all services, as that is their service model. Next slide, please. And now I will pass this on to Sharon.
Good morning. I was trying to figure out my mute button. Unfair marketing practices include misrepresentation, restraint of competition, choice of insurer. Misrepresentations can include omissions as well as misleading or false entries. Restraint of competition includes boycott of an insurer and intimidation. Choice of insurer includes requiring a purchase of insurance as a condition of contract not related to insurance. And home solicitation and sales includes a clear statement on the intent to sell insurance as part of the visit. Next slide, please. Next slide, please. Prospective buyers of disability insurance must be provided with clear and unmistakable statements, explanations, advertisements, and written proposals concerning policies offered to them. This includes printed and published material, including the internet and web pages, social media pages, including social network websites, descriptive literature and sales aids of all kinds issued by an insurer or agent for presentation to members of the public, and prepared sales talks, presentations of materials used by intermediaries, and representations made by agents in accordance with these talks and exhibits. All advertisements and representations must be truthful, not misleading, and must accurately describe the policy to which the applicant is applying. Note that an advertisement means printed as well as oral representations. Advertisements may not directly or indirectly make unfair or incomplete comparisons of policies or benefits. And lastly, advertisements may not falsely or unfairly disparage, discredit, or criticize competitors' policies, services, or other business practices. Next slide, please. OCI has staff that look at websites, media posts, and mailings. and we respond to complaints on any of these issues. If an application was taken over the phone by an intermediary, INS Section 6.61 specifically requires the agent to keep the application for 3 years. That is considered a record even if taken over the phone or conducted online. Excuse me. For e-delivery, if an oral communication or recording of an oral communication can be stored and reproduced, then the oral communication may qualify as a notice or document delivered by electronic means. Companies are required to file forms with us. The definition of form includes the application, and the insurers must keep copies of those filed forms. If a company didn't file an application with OCI as a form, they cannot rescind the policy for material misrepresentation on the application, because the application would not be considered part of the policy, plus they don't have a copy of the application, so they can't establish misrepresentation. For electronic or online applications, we view the screen as a type of form, and we would expect to be able to review that form. OCI monitors for marketing tactics that steer enrollees to non-ACA compliant products, such as short-term limited duration and healthcare sharing ministry. Next slide, please. Which of the following insurance is generally exempt from OCI jurisdiction? A, healthcare sharing ministries. B, self-funded ERISA plans. C, Medicare Advantage plans. Or D, all of the above. The answer is D, all of the above. Next slide, please. Here are the common federal laws that can impact health insurance. Medicare is a broad program of health insurance designed to assist the nation's elderly to meet hospital, medical, and other related costs. Medicare is available to most individuals 65 years of age and older. ERISA is a federal law that sets minimum standards for most voluntarily established retirement and health plans in private industry to provide protection for individuals in those plans. COBRA gives workers and their families who lose their health benefits the right to choose to continue group health coverage provided by the group health plan for a limited period under certain circumstances such as a voluntary or involuntary job loss, reduction in the hours worked, transition between jobs, or other life events. Qualified individuals would be required to pay the entire premium for coverage. The Mothers Health Protection Act, or Newborns Act, includes important protections for mothers and their newborn children regarding the length of the hospital stay following childbirth. This requires group health plans that offer maternity coverage to pay for at least a 48-hour hospital stay following childbirth, or 96 hours in the case of a C-section. The Women's Health and Cancer Rights Act of 1998 is a federal law that provides protections to patients who choose to have breast reconstruction in connection with a mastectomy. This law applies generally both to persons covered under group health plans and persons with individual health insurance coverage. HIPAA was developed in 1996 and became part of the Social Security Act. It sets national standards to protect individuals' medical records and other personal health information. It gives patients more control over their health information, and it sets boundaries on the use and release of health records. MHPAEA prohibits group health plans that offer mental health benefits from imposing more restrictive annual or lifetime limits on spending for mental illnesses than are imposed on the coverage of physical illnesses. The Affordable Care Act ensures that all Americans have access to quality health care that is affordable. It eliminates the pre-existing clause that prohibits some consumers from not being able to purchase a quality health care plan. And lastly, the Federal No Surprises Act is effective for services received after January 1st, 2022. And this law protects a consumer from surprise bills for emergency services from an out-of-network provider or facility and without prior excuse me, without prior authorization, out-of-network cost sharing, like out-of-network co-insurance or co-payments for all emergency and some non-emergency services. It also provides protections for out-of-network charges and balance bills for supplemental care, like radiology or anesthesiology, by out-of-network providers that work at an in-network facility. Next slide, please. Medicare is federally funded and regulated under the U.S. Department of Health and Human Services. Medicare is available to most individuals 65 years of age and older. And although people with end-stage renal disease are eligible for Medicare, there is also a state mandate for coverage of kidney disease. Wisconsin is an exempt state from the federal Medicare supplement products, which I will explain further in the next slide. Next slide, please. Wisconsin is a waived state, which means we provide a different kind of Medicare supplement policy, not labeled with letters. Medicare supplement policies in Wisconsin have set minimum comprehensive requirements for supplemental coverage. Individuals have 6 to 7 rider options available that must be separately priced from the base coverage. Some examples of these riders are foreign travel, Medicare excess coverage, and inpatient deductible coverage. If a consumer comes to you stating that they are being quoted a supplemental plan with a letter name, advise them to make sure that this is a Wisconsin plan being quoted and not one based in another state. Insurance companies sell policies referred to as Medicare supplement policies to fill coverage gaps left by Medicare. Medicare was never intended to pay 100% of a person's medical bills, but was created to offset medical expenses by providing basic foundations of benefits. Medicare requires a person to pay deductibles, and many Part B expenses are paid at 80% of the Medicare approved amount. Next slide, please. Insurance companies have the right to ask for additional information or documentation to help adjudicate a claim. Consumers may need to become involved with the process of assisting in obtaining this information from their provider if there seems to be a disconnect between the company and that provider. And because I have a little bit of a cold, I'm going to turn this over to Shelley. And the next slide, please.
Alrighty then. So with regards to non-renewal of insurance, non-renewal of a policy refers to the termination of a policy at the expiration date. If an insurer decides it does not want to renew your policy, it must mail or deliver to you the non-renewal notice at least 60 days before the policy expires. The non-renewal notice must be clear and concise to the consumer and cannot use just general terms. Reasons that are not acceptable under this definition would be condition of a property, damage to a vehicle, or coverage just not offered. Next slide, please. This slide pertains specifically to midterm cancellations. Nothing is official until a consumer has been given a 10-day notice. This notice could be provided by email, assuming that there is language in the policy informing an insured of this, and that the insured has agreed to this method ahead of time. The Court of Appeals in Wisconsin has ruled that when using the Postal Service to mail a cancellation notice, the written notice to the policyholder refers not to the receipt of that notice by the policyholder, but to the date the notice was mailed by first class, which as is permitted by state statute. Next slide, please. So some of the scams that are currently targeting Wisconsin consumers have to deal with, more than often than not, short-term limited duration plans with limited coverage, pre-existing condition exclusions, limited provider networks, and they can also include unnecessarily unwanted benefits that often appear to be included or free, but actually pad the cost to the consumer. For example, junk fees. Other times, the companies are healthcare sharing ministries that are not licensed or authorized insurance products. There are legitimate HCSMs or healthcare sharing ministries out there that operate under a federal exemption, but there are a lot of bad actors cloaked as healthcare sharing ministries, taking money from people and not paying any benefits. Not altogether fake products, but misleading. Misleading, even by omission, is a violation of insurance Wisconsin law. Next slide, please. So here's an example of one of the scams we have seen in the past. Consumers search the internet for health insurance, Obamacare, or Marketplace. They even have searched in the past for Trump Care and are directed to websites enticing them to enter contact information to receive rates. The unauthorized use of logos, as directed at the bottom of that screenshot, of well-known companies gives the illusion of legitimacy and can lead the consumer to believe they will receive information on coverage with these characters. Next slide, please. So again, another example of a healthcare scam that we have seen out there. This text falsely and misleadingly references the state of Wisconsin in the context of recently approved new insurance programs. As you can see, it makes it seem like putting the governor's image on this Facebook post makes it look legit, and it's not. Next slide, please. When a consumer falls for a scam, don't wait, number one. File a complaint with our office. We can always refer the complaint to the Department of Ag, Trade, and Consumer Protection, or even another appropriate agency or jurisdiction if it's something that falls outside our realm. But these are some of the things, again, that we have seen in the past. Filing a complaint with our office doesn't cost anything, and it gives us the ability to do a complete investigation. And it also, by filing a complaint, establishes a potential pattern of a company or an agent or an entity that maybe we can end up somehow taking administrative action against. Next slide, please. So anyone under INS 6.85 has the right to file a complaint with our office. And again, as we've talked, insurers must notify consumers of that right to file a complaint. Next slide, please. So what exactly is a complaint? A complaint is a dissatisfaction you are having with an insurance company or an insurance agent. The Consumer Affairs team at OCI is dedicated to protecting and educating Wisconsin insurance consumers. A complaint must be filed in writing to allow for their side of the story to be presented to the insurance company, agency, agent, pharmacy benefit manager, or medical provider. Wisconsin's open records law was enacted in 1982 and is a series of laws designated to guarantee that the public has access to the public records of government bodies at all levels. When you file a complaint with our office, that does become an open record once the complaint is closed. Generally, any persons may make an open records request, but there are some restrictions. We do make all efforts possible to protect a person's private, financial, and health information. Within our website, there are electronic forms available, and those would submit directly to our office. I do notice in this slide, though, that I didn't update. We now have 4 specific forms available to submit that encompass what I would call a regular complaint, a pharmacy benefit complaint, a surprise billing complaint, and we also now have insurance fraud complaints. Next slide, please. As a health insurance examiner, these are some of the questions that I ask myself when reviewing a company or agent response to a complaint. Did the company identify the problem? Was the company's action proactive? Was the do not want to see the problem continue, in addition to making sure a consumer was not harmed or wronged in any situation. Next slide, please. On our website, we also try to educate consumers prior to submitting a complaint so they know what to expect from our agency. The company, agent, pharmacy benefit manager, or provider response should provide our office with a clear and detailed picture of the events surrounding the complaint and what, if any, resolution can be provided to assist the situation. We try to also educate consumers on how their insurance policies work, and we have those. The way that we do that is by providing publications and links to other documents and websites. Next slide, please. So here's some of the things that we cannot do. We cannot act as a lawyer or give legal advice. We cannot make medical judgments or determine medical necessities. We also try to educate consumers upfront on situations that we cannot handle for them and to look at consulting with an attorney about their specific rights. As a health insurance examiner, the main issue we run into a lot is being asked to make a medical determination. We are not healthcare professionals, and we cannot read medical charts or doctor's notes to make any kind of an assessment. Medical necessity is a term in the insurance contract itself, and Wisconsin law does not define medical necessity or mandate the criteria that insurers must use to determine it. Each insurer establishes its own criteria for determining if a particular service or treatment is medically necessary. We can't determine what a consumer feels is the right amount of money to make them whole again. And as we've touched on, there are times when we don't have jurisdiction in a matter. We will refer that complaint to the proper entity for review and assistance. And lastly, we must remain neutral in all complaints. Our role is to ensure that our state laws and statutes have not been violated, and in the case of the insurance company, we must make sure that they have followed the terms and the conditions of their members' policy justly in doing what they are doing. Next slide, please. So we've reached the end of our session at this point. Again, these are just some of the resources that we have available on our website. Again, that website address, the main page is oci.wi.gov, G-O-V as in Victor. And at this point, Elizabeth, I will turn it back over to you.
Awesome. Thank you so much, Shelley and Sharon. So we will give a couple of minutes to see if anyone has any questions. If you do, please go ahead and put them in the live Q&A. And as a reminder, The PDFs of all of the sessions will be available after the conference has finished. Was there an answer to the polling question? So we had 2 polling questions. I don't know if it was the first or the second one.
So the second one was the one that says, which of the following insurance is generally exempt from OCI jurisdiction? The were health sharing ministries, self-funded ERISA plans, Medicare Advantage plans, or all of the above? And again, the answer was all of the above. Not sure if
Awesome.
that
Thank
was
you.
the question. Okay.
Yeah, yep.
Okay.
Thank you for the question, Brandis. Shelley,
You
thank you
bet.
for the answer. Could you please report the licensing required? I don't know if we could get a little more information about the question on licensing. Could you please repeat the licensing required? The licensing required for which intermediary are you interested in the licensing information about? For an agent. Shelley, do you have more information or a repeat of the information for licensing required for agents?
Well, it wasn't something that we got heavily touched on within this slide deck. Um, let's see here. I'm just looking at my slides. I apologize. I'm not sure if Elizabeth, you could pop back maybe to slide 11. I'm not sure if that's what Luciana is referring to,
Let's see here.
or when a license is required.
Go back quite a bit here for a second.
Okay.
I don't want to make anybody sick.
Just don't look.
Oh, I think, did I go too far?
No, let's see. No, you're getting there. Let's go to slide 13, titled "Is a License Required?"
Perfect.
Okay. So again, Luciana, I'm not sure if this was the slide you were reviewing or referring to, but these were just some very generic examples of situations and scenarios. Okay, good. That we talked about where a license would or would not be required. Again, the first scenario, the answer was no. In the second 2 scenarios, the answers were yes to each one of those. So really it comes down to um, going door to door is very essential to making sure that you are a licensed agent. And also, just like it states, when you're talking to another person about their insurance needs and you are being compensated by an insurance company, or an insured, I guess, to do those types of advices. Those are situations when you would need a license. Not necessarily if it's what I would call maybe water cooler talk. Um, you're at the office and you just happen to be talking to somebody passing by. You wouldn't need a license for something like that. But 9 times out of 10, I would say it's probably a situation where you do need to have a license. Hope that helps.
All right, and I also have the link to the OCI site for licensing frequently asked questions that I can put into the Q&A as well. As a response, here we go. All right, any more questions for Introduction to Insurance today? All right, so we will be back at 9:50 for our next presentation from OCI on the ACA for navigators and certified application counselors. We've got a little bit of extra time here, so hopefully you can enjoy a couple of extra minutes, and we will see you at 9:50. Thank you.